Good evening, everybody. We're going to bring the meeting to order, and welcome to the April 26th Planning Board meeting. We're going to start the meeting with a prayer, followed by the oath of allegiance. Allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Adequate notice of this meeting has been provided, indicating the time and place of the meeting in accordance with Chapter 231 of the Public Laws of 1975 by advertising a notice in the Star Gazette and the Express Times, and by posting a copy on the bulletin board in the municipal building. So Beth will do roll call.
Sure. Members Correa.
Present.
Simmons. Fox.
Here.
Pryor.
Here.
Snyder.
Here.
Wolf.
Here.
Mayor McKay.
Here.
Vice Chairman Oczewski.
Yes.
Chairman Johnson.
Here.
Alternate Fishback. Alternate Kern. Here.
We'll start off with the old business of approving the meeting minutes for March 22nd, 2017. Is there any comments on those minutes? If there are no comments, I'll take a motion to approve.
Make the motion. Motion. No.
Tom, do you want a second? Okay, so we got a first and a second.
Yeah.
Last chance for discussion on this. We're all good. So Beth will do roll call on it.
Members Correa. Will abstain. Carlos.
Yes, I wasn't here, so I just abstained.
Member Fox.
Also abstain, I suppose.
Pryor.
Yes.
Snyder.
Yes.
Wolf.
Here.
Mayor McKay.
Yeah.
Vice Chairman Oczewski.
Yes.
Chairman Johnson.
Yes.
And alternate Kern. Yes.
We have a resolution tabling the discussion of the RLM manufacturing zone district until the court made their decision. This is the same resolution that was sent out in the email, correct, Beth? Hasn't changed?
Correct.
Okay.
I should indicate that the court has rendered a decision, but this was the action of the board taken at its last meeting, and so the resolution should still be adopted.
Okay, I'll take a motion to adopt the resolution, then we can follow it with discussion if needed.
I'll make the motion.
Looking for a second?
Sure. I'll second.
We got a second. Any discussion on this?
No, I think it should be clear that this is just perfunctory because the court did give its decision. So otherwise it would be confusing.
Yeah, I did actually talk to Tony about that, and this is kind of commemorating what we voted on last meeting.
Go ahead.
No, go ahead. Joe, go ahead.
This was the motion that was made, and actually the mayor made it, I seconded it. I'm surprised at his hesitation. I didn't expect the decision to come down this fast. So the motion in itself is harmless. I do know Tony gave a discussion of it's not over till it's over. I'll paraphrase what Tony said, which the court decision doesn't necessarily end, the issue. And then you have the conflicts hanging in the air, and you run the risk of, if conflicts are determined to be true, whatever action we take could be overturned. So I just point that out. But this resolution in itself is harmless.
I agree with you. I think it just commemorates the motion that happened in the previous meeting. Did we get a second?
Yes.
Okay. So any other points of discussion? I read through it. It looked to be accurate, in my opinion.
Tony, is your professional opinion that is still beneficial and it makes sense to do?
It makes sense to do because you need a resolution to memorialize the action that the board took. That was the action that the board took, and this reflects that. It's not terribly useful going forward because the court has rendered a decision. I don't know if there will be an appeal to the New Jersey Supreme Court or some other collateral attack, but as things stand now, that's the decision of the court, but I see no harm, no foul in adopting the resolution.
Okay, if no other comments, then we'll do a roll call on it, or abstain if you need to.
Member Fitzsimmons is arriving at 7:08. Okay, for the resolution, Member Korea, you'll abstain.
Ken, you were present.
You
I was
just
present.
Sworn in, so can you vote? Yeah? Okay.
Okay, Ken, we're voting on the resolution that came in through the email regarding our discussion last with tabling the ROM until the court.
I abstain.
So just so you know where we are right now, that's the motion on the table.
For now.
Left my phone and...
That's okay.
Abstain.
That motion's accurate, Tony?
You're gonna abstain?
Yeah.
Okay.
So Ken's caught up? Okay.
Am I waiting?
Oh, no, I just wanted to make sure Ken knew what we were voting on. We're good to go, Beth.
Okay. Fitzsimmons,
Resolution.
you're going to table the resolution? You
This-
agree to that?
The one that we should
Yes.
table discussion.
Yep, yes.
Yes.
Clark?
Yes.
Pryor?
Yes.
Schneider?
No.
Wolf?
Yes.
Mayor McKay?
Yes.
Vice Chairman Chesky?
No.
Chairman Johnson?
Yes.
And Alternate Frank? Yes.
Before we continue our application hearing, I believe we have some certifications to do because there were a few members present. The hearing was three meetings? If I remember correctly, I think it was 3 meetings. So we need certifications from the people that missed a meeting to make sure that they saw the video or read the minutes. I don't know the list.
Minutes don't count, you need a transcript. So it have to be the video.
Is that true?
Say, Tony? I didn't hear you, Joe, I'm sorry.
It lost its transcript, we didn't have a transcript for that meeting, the minutes are not a transcript.
The minutes are not the transcript, is there, what was reviewed?
It's irrelevant. We've both watched the video of the appropriate date.
Okay, so we have, we need this certification from John, from Donna, anybody else?
And I think watching the video is sufficient and looking at the exhibits because oftentimes there's no transcript and people just listen to the tape. I think it's easier to figure out what's going on and watching a video and seeing who said what than trying to listen to a tape and discern what was said by whom. I think that satisfies the requirement of the statute.
Was there anybody else that needs to do the certificate as well? Carlos, did you?
I'm going to abstain from
You
the
got
vote.
abstain? Okay.
Correct.
So they need to sign their certifications and let Tony notarize them.
All right, let's take care of that.
Can I just make a note for the record, Eric, if you don't mind?
Sure.
I just want to make a note that Member Pryor had said that I missed expert testimony that night in the last 14 minutes that I left the meeting. I did review the video, and I would like to just go over minute by minute what I missed. 9:21 started with the board questions. 9:32 started with public questions. 9:43 discussion was done. At 9:42, Vice Chairman Olszewski waved goodbye to me, and I was in the back of the room, and I spoke to Mr. Farrugia and Mr. Snyder and let them know why I was leaving, and I left the room at 9:44, so I actually missed nothing. But I will sign it, because I did miss, but I did not miss any expert testimony, is what Member Pryor had said. So, for the record, thank you.
So to be safe, you'll still do the...
Yeah, I'll still sign it
Okay.
because I missed a meeting. I missed 14 minutes of a meeting, but it was not expert testimony as Member Pryor had suggested.
Well, I do remember you leaving earlier for about 2 to 3
I
minutes.
did not leave earlier, Mr. Pryor.
Excuse me, I got an email from a resident who offered the tape. We have 2 tapes, one from the front, one from the back. She sent me an email. Beth, do you remember her leaving?
Yeah, Don, I don't know if you remember, but you got up from your table and you went over and picked something up on the floor, and then you walked out of the meeting while Mr. Peck was addressing one of the witnesses. I don't recall who it was exactly.
So that's
No,
what
didn't.
I feel, but I'll accept your certification. I'm not going to argue.
I wasn't asking you to accept my certification. I was just pointing out that I did not miss expert testimony.
We have two tapes of this?
I think
If you can sign those and hand them up, let's move on.
you have the search, sir.
I would like just a clarification on it. There's two tapes of this meeting? I thought there was one.
There's a tape from the front and a tape from the back, and you can see things from the front that you
Are they
can't see
both
from the
online?
back.
Well, why is only one online?
Same tape, if you look over here, this is what appears on the monitor. When I do the minutes, that's what appears to me, both of those screens. I think that's what Mr. Pryor's referring to.
That's right, and the one that's posted, you can see the board, you can see the witnesses, you can see all the transactions.
Well, why don't we post both?
Because no one's interested in the audience or who walks out the door.
Apparently they are.
No, I saw her walk out, so I'm just saying somebody
Right.
got that tape and told me that they recorded the time. I didn't bring the email.
Right, okay. Well, we should...
Not worth arguing about.
Yeah, we should post both tapes, though.
So we're going to listen to the same thing from the front of the room and the back of the room?
Sure, if you're going to question people leaving and dropping a piece of paper, then yes.
Put that to a vote, Eric?
Are we suggesting that we post both cameras online, or that you don't need an Oprah request to do the camera from the back, you just come in and ask for it?
No, it wasn't an open request.
So do we want to post both online, is that?
I think it's silly, but
Don't I sign the paper?
I said I'm done, so...
Let's move on.
There-
We have business to conduct.
We can talk about this later, if you want to make a motion now to post both, but maybe we can think about it too. We can talk about this next meeting if we want to.
Sure, fine.
I think the important thing is that everybody saw the video, they needed to. We can move on, and Donna has stated her case on the timing, which appears to be accurate based on the video of in my opinion, based on the video of the looking at us. I guess that's the back camera. I personally haven't seen the front camera, but I don't plan on it. So I guess we'll get the search done and then we can move on.
Sir?
I fill it out correctly.
Well, you're done.
I'll have to put in the other stuff.
We don't need to see ID.
He's a king.
Okay, that's fine. Thank you.
So I took it right off of the,
Yeah.
second line would be the where it says skip legal.
Okay.
So your name there. I know.
Oh, there it is.
Oh, there it is.
Yeah.
It's one of the other stuff.
Yeah.
Yeah, is that what that represents?
Yes.
Or that? It's still coming.
While we're waiting for the other certification to be passed up, I want to address an email that I received concerning the Perugia self-storage application. Actually, I received more than one, but the first one that I want to deal with is an email that I received from Board Member Pryor, and I'd like to read it into the record and tell you what my opinion is concerning this.
Tony, could you put the microphone?
Sure, I'm sorry. Tony, I received direct reports from Bill Wright, Gary Van Vliet, and Beth Diltz that Eric Johnson has approached them outside of the hearing and asked for their opinions on the Perugia application. It is my understanding that all discussions, presentations of evidence, questions, and comments with regard to a pending application must be done on the record and at the public hearing. Each case is to be decided strictly on the basis of facts adduced at the hearing, viewed in light of the statutory and ordinance requirements. Further, the applicant, the board, and the board's professionals have a right to hear all comments and cross-examine all witnesses. If the reports are true, and I have no reason to believe they are not, Mr. Johnston's ex parte communications could jeopardize whatever decision the board makes. I am sure his discussions were the result of his inexperience. Nonetheless, it has been explained to the board that their function is analogous to a jury. As chair, Mr. Johnston should know better to be on the safe side. It is my opinion that Mr. Johnston should acknowledge his actions and recuse himself. My suggestion is you talk to him and ascertain the facts. I would hope we could solve this offline rather than at Wednesday's meeting. Please advise. Joe Pryor. When I received this, I forwarded this on to Eric to get his response and reaction. And what Eric indicated to me was that he did indeed have discussions with various individuals regarding the application, and he asked my opinion as to whether that would disqualify him from continuing to consider and vote on this application, which I hope, God willing, this thing is brought to a vote this evening. My reaction, I asked him two questions. I said, first, if you do take action on this application, will you consider not what individuals said outside the four corners of the meeting room, but only the record as it was created within this building, meaning the testimony, the exhibits, and all of the evidence that was placed into the record here? And the answer to that was he would consider only that. I also asked him if he remained objective and kept an open mind regarding the application, and his response was yes. Based upon that and those responses, I do not see a legal basis for disqualification here. I can find no authority that prohibits a board member or a board professional from discussing an application with members of the public, with other members of the board, provided there is no violation of the Open Public Meetings Act, or with board professionals. I think it's something that happens on a regular basis, and I don't think it goes so far as to create an appearance of impropriety. And I just don't have any issue with it. I'll also say that I said to Eric, maybe you're surprised that I'm offering an opinion here, as opposed to the other issues that have been raised regarding conflicts of interest in the ROM zone, where I refused to offer an opinion. And I did that for this reason, because I think it's pretty clear here. On the other matters, reasonable minds could differ as to whether any members have a conflict, and I'm not going to sit up here like Solomon and make a decision one way or another. I think that goes beyond the scope of what I am authorized and responsible for doing. So I've offered my opinion regarding Mr. Johnston's alleged conflict on this application. I don't think one exists. If anybody else has anything to say, I'm more than happy to listen to what they have to say.
Well, I'll just say I accept your decision. That's what I asked for. I still think it's bad practice and not in accordance with municipal land use law to walk around outside this meeting and ask for opinions. It's clear witnesses have a right to cross-examine people. You're to make your decision on the record, based on what's on the record and what's in accordance with the law. So that's my feeling. But you did what I asked you to do. I accept it, and it's over, as far as I'm concerned.
I do agree with one thing. Well, I do agree with a lot of what Mr. Pryor said, but I would urge the board to just curtail your activities outside the meeting room with members of the public or the applicant regarding an application while it's pending. I just don't think it's a good practice. Nothing really good can come of it. If there's a member of the public that wishes to make a statement, express their views, there will be ample opportunity for public comment after the applicant has concluded with its presentation of the case, and I think that's probably the most appropriate time to hear from the public.
Do you have any comment on discussions that a board member or a board chair would have with their secretary? To me, those conversations, have always existed. You have to communicate with...
I think they've always existed. The professionals certainly speak amongst themselves at various times regarding applications, but does that run afoul of the Land Use Act? I don't think it does. I don't think it does. As long as your decision is based upon the record that's created here, and you keep an open mind during the course of the entire proceeding, I think that's what you're obligated to do. And you've represented to me that you've done and are doing just that, and with that, I'm satisfied.
And I'll accept that representation.
Thank you.
I accept it too, and again, I think it's diligent for all of us to be aware of what happens outside the room, even if you're approached by somebody, not to be rude to them, but watch the conversations, because you can be led, which could come back and something like this could happen. But that being said, I think we're ready to move on. So we have the applicant here, and I believe we have the last cert for the...
I should indicate, and Mr. Peck, you're free to step up, but I did receive a call today from David Gardner, who advised me and confirmed, and I also received correspondence from his attorney that he would not be appearing this evening, that for lack of a better description, the parties met. They have modified the plans. Those modified plans have been submitted, and it's my understanding that based upon those plan modifications that Mr. Gardner, or Larkin, whatever you want to call it, has withdrawn his objection to the application. He acknowledges that it's still up to the board to make a final determination, but he wanted to go on the record indicating that he has no objection to the application that has been submitted as revised. I think that makes our job infinitely easier. And I also think that the revisions to the plans result in a better design, aesthetically, functionally, and I think we all benefit from that. So,
did everybody get a chance to pick up, I think it was 5 sheets of plans that have the revisions on them? Okay, good.
Mr. Peck, in light of this, what I would suggest perhaps is that someone briefly go through the plan modifications. I would, to the extent of any of the professionals' testimony, changes as a result of the plan revisions other than your architect, we'll hear from them, but I think we just need to see what those plan changes are, and we'll see if the public has any questions and comments, and we can get to the finish line.
And particularly if you can emphasize what variances may no longer be required, or how your new plans have affected the variance that you're asking for. I don't believe we have that yet, but I'm curious on how the changes affected everything.
Sure. And thank you, Mr. Chairman, members of the board. Certainly I concur with Mr. Cicero's summary. My client's intention tonight is not to belabor the point. We're not going to present any new testimony. We have Mr. Doug Coleman here, our architect. He'll explain to you the changes to the design, leading to those. We have Tom Decker, our engineer. He made some minor changes and additions to the landscaping, and that's it. Unless you have any other questions. As far as the variances we're seeking, I don't believe they changed. I had a question in my mind whether or not height variance was going to be affected, and we still need a height variance. It's just, I don't know offhand, maybe Doug later on can explain whether it's still 44.6 feet versus 44.3 feet or 44.9 feet. That I don't know. But everything else remains unchanged. Same building box, same layout, same everything. Just nice and simple.
A question for you or professionals, I'm sorry to interrupt, but your variance for the number of stories would no longer be required, if I understand it correct, because the basement level does not count as a story?
That's actually, That's actually true. I'll defer, of course, to the board planner. I know the height isn't changed, but yeah, the stories, we're going to have 3 above ground, 1 below ground.
If I remember correctly, you didn't exceed the height, but you exceeded the number of stories. So we need...
So the height hasn't changed, but the story issue...
Well, in other words, that variance is gone.
So that variance...
4 meetings.
George,
Come back and take...
George, do you agree with with that assessment on that variance no longer being required?
Correct. I believe I agree with Mr. Peck that the other variances that we had put together still are ones that the board have to consider, but the height variance for the number of stories is gone as a result of the changes they've made.
And your square footage remains the same?
I believe the square footage is still 31,200 feet. There have been, a couple revisions along the road. We're back to the original.
So you're back to 30...
31.5.
You're no longer down to the 29.
Forget it.
I'm out.
Yeah, we still need the variance for the 4 stories because of the definition of a building, and if a basement's used for business purposes, it's considered a story, even though it's below ground level.
So we seek a variance for a 4-story building, 3 of which are above ground.
Correct.
1 of which will be below ground. Yes.
And now the variance is back for the loading dock as well, because you're over the 30,000 square feet. I'm asking, it's a question that I'm assuming that's back in there? Okay.
Call your first witness.
Call Mr. Doug Coleman, who I believe was previously sworn. So, Mr. Coleman, if you can educate the board about the revised plans.
Sure. As Mr. Becker said, after the last meeting, we had an opportunity, myself and Mr. Perugia had an opportunity to go meet with Mr. Gardner. Some of the concerns that Mr. Gardner had said at that meeting, as well as some of the concerns the board members had said, we had taken to heart. One of the things that Paul had asked us is whether or not we can move this 1 story into the basement. And my answer at the particular time was, when we did our original geotechnical reports, we determined that it would be, we said, infeasible from a dollars and cents standpoint. But realizing where things were going with the board, the Perugias hired their engineer to go back out to the property to do some additional test holes to determine where there was going to be a problem, not be a problem. Although it's going to cost more money to do it, it is feasible to do it, so we made the decision to do it. And in doing so, we also went back, as Mr. Gardner was saying the last time, that he wouldn't object if this thing was 3 stories and had a regular pitched roof on it. So by pushing that floor under subsurface or below the ground, it allowed us to come back and put a regular full pitched roof on the building, whereas before we had more of a mansard type roof. And we also were allowed to go to more residential character materials. I'll show you in a minute that we've gone to asphalt shingled roof, we've gone to clapboard siding, shutters, and more windows. So I marked these exhibits based upon where we left off the last time. The first exhibit I'm showing you, which is our sheet A1, which is exhibit A15, with today's date on it. If you look to the bottom right, it now shows what that first floor plan is going to be, and then it shows what the lower level basement or subsurface plan is going to be. Basically, we were able to drop it back down, and we just continued the staircase. So that was not the difficult part. Obviously, the next exhibit, which is exhibit A16, which is our sheet A2, just shows the 3rd and the 4th floor the way it was. One of the new exhibits will be A17, which is basically our sheet A3, which now shows the new front elevation and the new rear elevation. If you'll notice from the last time, we changed to a pitched roof on the front of the elevation. We changed to an additional siding. We're using brick, cut face block, as well as clapboard. We added more windows and more shutters to it, and then we repeated that across the back of the property to try to make it more, so it didn't appear to be that box of a building. The question was asked in terms of what the building height is. Right now, we're at 44 feet 4 inches, so we're staying under that 45 feet requirement. Our exhibit A18 is our sheet A4, which now just shows you the right and left sides. On these, we also continued the windows on the 2nd and 3rd floor, and we also added the shutters on the other side, and then we went back and added additional landscaping that the engineer will testify to. The additional landscaping that we added to that was really in response to Mr. Gardner's concerns about what it was going to look like. The last time, based on one of the objectors, they had questions about what the roof would look like. I had made the comment, anybody with a pencil can draw one, so we drew one. Basically, it's showing you that it's now a new full pitched roof. So even from a distance, you'll see it. It's going to be a residential scale roof, big hip to the back, there's a hip to the side, and then basically you'll see the slopes in there. And that is our exhibit A19 sheet S4. Then we get to the new colored rendering that's in there. And what's happening, I also have, if you look past that, the back two sheets of these are the actual colored renderings up close to it. We went back and we redid the rendering, showing you a little bit more in terms of what the color palette is going to be. Mr. Cruz just said it was going to be more of an earth tone type materials. We are using clapboard, we are using brick. We have a cut face block on the lower level. We've added in the windows. We've also then gone back and changed the roof design to make it a little bit more residential in character. So that is the front of the building. And then our exhibit, A21, today's date, shows the rear of the building. And it's just showing again that we're having what the color scheme is, what the roof design is, and the additional bustering of the landscaping in there. So, based on this, we determined that we could go back and get that lower level to work. It's going to cost more money to do it. The roof's going to be more money to do it because before, we were actually building storage facility spaces up on that roof. We're not really doing that. And one of the questions came up about the loading dock. And what's interesting about it, in typical warehouse space, one of the things they're looking at is there's very little common area in a typical warehouse. In this particular type of facility, there's a lot of common area. And because in a warehouse space, everything's usable to the person that owns the warehouse, in this, they're only utilizing the space that they're renting. So right now, we have a building that's 31,580 something square feet. Only 18,000 of that is usable to the tenant. The rest of it is common area. So there's a very high common area to this particular building. It's about 58% of rental space compared to a warehouse that normally has 100%. So our testimony, or my testimony, would be under the requirement of having two loading docks for a warehouse. You could see that when you're utilizing all the space. But in this case, we almost have a 50% of the building being utilized as common area, and it's not going to have storage in it. It's just going to be the hallways, the office, and all that area. We kind of feel that the additional one loading space works. But our testimony the last time was if the board felt so, we had parking spaces in the front. We could take 3 of those parking spaces and strike those as the additional loading area if the board so felt so.
Did you say you had storage on the 5th floor? 5th floor? The roof.
No. The last time, if you remember, we had a square building, and what we did is we ran a mansard roof across the top. What that mansard roof did was it hid the 4th floor. Now we don't have, this is just attic space right now, it's trusses.
Okay.
So we're no longer storing up in that area. And I was just bringing the attention to the fact that a building like this has a very high common area because you need the 5-foot wide hallways to get everybody to the storage space. So we felt that the one storage or zoning dock or area was sufficient.
Do you have any mechanicals up top?
There will be mechanicals. There'll be ductwork. This is going to be a conditioned space, so there will be some ductwork running through the attic.
Are those fake windows or real windows?
They're going to be fake windows.
Okay.
Now, there may be an opportunity based upon a hallway or something to make it be a real window, but the intent was really just to bring in a spandrel glass so that you guys will look at it and think it's an office building.
A question on the building height.
Sure.
And I tried to pull up the grading plan, but I couldn't get it out quick enough, so I'll just ask you. The building height that's on your plans, is that from the highest grade elevation around the building or the lowest grade elevation? I mean, I know it's not perfectly level.
I think we took it from the engineers, so I guess you're going to ask them that question from the grading. But the intent, just to show, is we're going to stay underneath the 45 feet requirement based upon the definition of your ordinance.
Okay.
Your ordinance, I think, is based on average grade.
On average grade?
Right.
Okay.
And my testimony is we're going to be below 45 feet average grade.
Based on average?
Right. Because we have the ability to change the pitch on that roof.
And that concludes your testimony. I mean, if the board has any questions or members of the public, if there aren't any questions, I'd like to call my next and final witness.
Let's do the questions first, to make sure there's no board questions, and then we'll check to see if there's any public questions on that particular witness. Any further board questions?
I just went over the plan. Some of the dimensions changed, a foot here and a foot there, going around just to make it all work right.
The reason is because in some areas we had brick, in some areas we didn't have brick, and we're taking it to the
4 inches on each side, and they go away.
So the block is 8
yeah.
inches, the brick is 4 inches.
So you wind up with approximately the same usable floor space.
That's correct.
The setbacks that are current are the same setbacks that were in the original plans?
That's correct.
Okay.
I do think it's going to change a fraction, right? Just because of the way some of the walls, like you said, change a few inches, so the setbacks he showed are going to be off a fraction of a foot.
No, the setbacks are going to be the same. It's going to be the building, we have to measure to the outside face of the building. So if I'm using an 8-inch block or a 4-inch brick, I'm still measuring my setbacks from the outside face of the building. So if we're going to tell you we're going to be 40 feet off the front, it's 40 feet off the front. It's not 40 feet minus the thickness.
Well, I'd ask the engineer then, because, I mean, you got the width of the building chain and a few other things. You can't wind up in the same point. You're measuring from a diagonal, property line on an angle.
Oh, I thought you meant you were taking the building finish thicknesses into
No,
consideration.
I'm saying that the setback will change fractionally from what I see. I don't know the exact number, but
Right, so Joe, so they were holding the inside dimensions,
He's here. So
Yeah.
and the wall got a little thicker, so that reduces the setback just slightly.
it won't move from, well, I'll let him testify. I mean, you showed 10 feet or whatever. It's not going to be 4 feet or
Right.
15 feet.
Then we will, at this point, we'll open it up to questions for this witness specifically from the public, if there is any. It looks like we have none, so, what? Do you have another question? Go ahead.
You know, and I don't know if it's valid, right? But I think I asked, and I'm not sure if it was me,
That's the one thing I did.
if we can go with one level underground. And I was under the impression it was testified on the oath that we said, no, it cannot.
No, when I started the testimony tonight, I said that Paul...
Not tonight, before. We asked before, can you go,
Right.
what, and it was absolutely not. We have sinkholes and whatnot.
What we said was, Paul asked the question last week whether we could lower the building down there, and I said, based upon the current geotechnical information we had, they said it was going to be infeasible, meaning it was going to cost a lot of money to do that. We then went back, after that meeting, met with Mr. Gardner, the Perugias then brought the geotechnical people back out to the site, did additional test pits in areas, and said, yes, it can be done. The design of the foundation is going to change because of the subsoil condition, but it's not as crazy as they thought, certainly because that's where the board was leaning towards. So it's a question of, you could say 5 stories and not get approved, or you could say 3 stories or one below and get approved, but it's going to cost them more money to do it.
It's definitely a better product, I would say, would you not? It looks nicer. I wish we would be in a position that we can make these determinations from the beginning and not because another resident complained and then we figure out it's either we get it down or we have objectors, so.
I do think some members of the board expressed concerns about the mass, and
And I think what I said
Thank you,
before was that
responded.
between Mr. Gardner's concerns and the board's concerns, the client went back and did a little more additional, due diligence and came back and said that it can be done. They weren't happy about it from a dollars and cents standpoint, but they also want to build it, so they understand that it's a give and take.
Understood. Looks like we have no further questions, so we can move on.
Thank you, Mr. Chairman. Call Mr. Tom Decker up. I was frantically doing like calculations and things. Actually, the only thing I'm going to ask Mr. Decker to testify to are the revisions to the landscape. Thank you.
I think we're up to A23.
22.
A20, you're on A22. I'm like A22. Exhibit A22 with today's date is the site plan. It's similar to the rendering that we had in the previous meeting with some revisions. Per Mr. Gardner, concerns about buffering and so forth, we've added a few more buffer plantings to the plan. We've added 4 Serbian spruces along the detention basin, which provides some additional screening from the detention basin and the rear of the building, and we've also filled in a few of the gaps within the buffer to the north. We also have a note on the plan that the the plantings can be field adjusted to the satisfaction of the board's professionals, so that when we actually get out there, we can tweak the plants so that they fill in the gaps and provide the optimal buffering. We've added four more Serbian spruces in those areas as well to fill in the areas. We couldn't really add too much more because you start overplanting and crowding, and the trees have a difficult survival rate. So that's really what we've addressed as far as landscape. With regards to the building, slight increase in size. I haven't done those calculations to give you a number, but we will still be holding the 10-foot on the southern side, and we'll make it up in a little bit on this corner in here. It'll be,
I assume that.
it'll be negligible. As far as our setback, so that's...
I did have one question about the landscaping. Obviously, the north side there, you're going to preclude access with equipment that route, so you have 10 feet on the southerly side?
We have 10 feet on the southerly
And you're going to
side.
maintain that for access?
We're going to maintain that clear. We have our storm sewers in that area as well, so we don't want to put any plantings on top of that. We'll maintain that for maintenance in the back and so forth.
Just quickly, and I don't think it's going to be an issue, but I see with other projects in town, specifically with the solar panels, that the trees dying over the course of whatever. Are we able to get something in writing that whatever dies within the next first 1 or 2 or 3 years? I mean, you guys would be interested to have that replaced by yourself anyhow, right?
It's going to be a 2-year maintenance bond. They have to complete the work, and they'll post a bond before they start the work. At the time they get their performance bond back, they'll have to post a 2-year maintenance bond. So if this is let's say it's a 6-month construction project, and the bonds are issued shortly thereafter, well, another 2 years of protection under the maintenance.
So whatever dies within 2 years is going
They'll
to
have
be
to
replaced?
replace it.
Yeah, and that applies to the trees as well as, pavement that might fail or anything like that, so it's...
Very good, thank you.
Okay.
A quick question. From this distance, it's hard to tell, but we still have the pavement size for, what was it, 16 spots or 18 spots? And then
18.
they were not going to be striped. But it looks like you filled it back in with grass.
No. Well, unfortunately, this rendering was updated with just the trees. We still have it here, but the intent is, and we've agreed that we will be paving that area, constructing those parking spaces. But as Mr. Coleman mentioned before, we'll be taking 3 of those spaces and striping them to reserve them as a loading area, to provide a secondary loading area if needed, in addition to the one by the trash enclosure.
Are there any existing trees that are going to be removed?
There are, well, most of the trees are along the northern border. I'm not sure, I'd have to take a look at the plans. We may have a couple that are coming out. To be honest, most of the trees in this area are not specimen trees, if you will. A lot of them are kind of scrubby and, don't really have much of a canopy, which is why we tried to put in some additional plantings in here to supplement that. But otherwise, this is primarily an open field.
I would suggest to salvage as much as you can for screening for the adjacent property.
No, we do, but if there's one if it's diseased or dead or poses a hazard, we're certainly going to take it out.
Understood.
I have a question, too. What's the distance from your building to the adjacent buildings? Because I commend you for everything you've done. I appreciate the fact that you took your 4-story and you were trying to make it look like 3-story, and now you've gone through all this work to bring the aesthetics into view, but bulk-wise and the variances of the side yard setbacks, I'm still concerned. I'm looking for a way to agree to this. So my thought is that the distance from building to building, if it's twice as much as what the setback is supposed to be, I can almost envision the property line being a little further off, meeting that distance.
We are approximately 60 feet from the strip mall to the...
And what's the side yard setback requirement?
The side yard setback requirement is 50. It's 50 feet.
So if you
We're
each
providing
had a
that.
side yard setback, you should be 100 feet from that building.
Right. The problem is that if we applied the 50-foot setbacks, we end up with a building envelope.
Right, I'm aware of the original concern.
Yeah. So we're 60 feet from this building, and we're about 95 feet from the daycare.
Because the adjacent properties they don't have any extra room.
No.
They're pretty much at the
They are
buildable envelope. They're at the 50.
They are at the shopping center to the south is at 50 feet.
Right.
And the daycare to the north is, they're also at 50 feet.
Okay, thank you.
Do you remember, relatively speaking, I was looking at the elevations that were put in there. This building is about 45 feet high. Do you remember the height of the adjacent building? 35 is in my head, but
The adjacent buildings?
Yeah.
We had peaks approaching, if not exceeding, 45 feet.
Correct.
Excluding the little chimney thing.
Right, there's different peaks. But I think like Warren Heights across the street, I think they're pushing 45 feet.
Yeah.
I can get up on Google or anything like that.
Yeah.
Relative to the immediate...
objection to that Google map, too.
Yeah, I think there was. I'm just kind of curious, relative to the south property right there, just to give us a rough ballpark, your building is approximately how much higher than what that roof line would be?
Well, we have to take into account topography and whether you're looking at the front of the stores or the rear of the stores, because the back end is lower.
It's lower.
It will be higher, but it won't be, I don't think, a towering height over the others.
Order of magnitude?
You had a plan the last time, it was a Google map.
Yeah, I know.
What was tested by the last time was...
But it's at least, I believe this building here is at least 35 feet. So we would be probably about 10 feet.
You know, what was testified to at the last meeting was the shopping center cupola is 53 feet high.
Yeah.
The Warren Heights buildings are 44 to 45 feet high. I don't have anything in my notes as far as the height of the daycare building or the strip mall building. Certainly it's not 53 feet high. Cupola is an architectural feature. So I can't give you that answer, but there are height elements around this building that are on the order of the height of this particular building.
Yeah, the Warren Heights buildings to the north are approximately the same height as this. They're 43, 44, 45 feet.
And the elevation's also a little higher, so I think the topography slopes up.
I think the site that self-applies with the height limits as well.
Yeah.
I was trying to envision it, refresh my memory on the height issue. I do think the fact that it's not square architecturally will pull a little off of... Yeah. And it matches the architecture of the adjacent strip mall, correct?
Yes.
More or less.
Yes.
It will be very compatible, I think, with the surrounding commercial uses.
53 feet.
Any other questions of this witness?
From board members today. Okay. We open it up to the public for this witness.
This is 40.
Any questions?
33, 30.
It looks like we don't have any, so back to the board. We'll give it a couple minutes here just to look over and think about what we just heard.
That would conclude our direct testimony.
Why don't we,
We talked about the Google. All right, so I think everyone's looking at the Google map. That was actually, I know that was presented at the last meeting. I actually prepared that from Google Earth. And when you take the cursor on Google Earth, it gives you some rough elevations. And when you go over the roofs, that elevation jumps up.
MSL, sea level.
Right. So the difference, even though the elevations may not be to any particular datum, the relativeness between the grade shot and the roof shot from Google Earth is within reason. I think what we found on the Google maps were very comparable to what I think Mr. Gardner's experts testified at the last meeting.
Yeah, I would consider it approximate.
Yeah, it's approximate. It's certainly not a surveyed number, but we were trying to get a handle for, based on information that was readily available.
For approval from the application overall.
If there's anyone from the public that wants to comment on the application, now's the time.
This is public comment on any questions that you have for the applicant or the plans that have been presented. It doesn't have to be to this expert witness specifically.
Board testimony, correct?
It's comment to
They
this
want
point.
to,
People get the opportunity to express their views. They've had the opportunity to question all the witnesses. They can come up and speak their piece if they're so inclined. Anyone?
We'll open it up to the public again.
No one.
It looks like. Okay, we've got no public comments on the application tonight.
Mr. Peck, do you have anything else that you'd like to add?
Other than, we believe that we have diligently and in good faith pursued development of this parcel. We've heard the board's comments over 4 hearings. We've heard the public's comments, and we've worked with our neighbor to accommodate their objections, and I think we are successful in doing that, given that the neighbor has formally withdrawn the objection, which in 25 years of doing this, I have rarely seen an objector actually affirmatively saying, hey, I no longer object. We are seeking several variances. The primary one, I think, is the lot size, but that's a pre-existing condition created by this planning board when it gave subdivision approval to the surrounding neighborhood. There was this remainder 0.91 acre lot left over, and it's in the HB zone district. Through all the testimony you've heard, this is a compatible use. It's a good use, and the variances that we seek, the dimensional variances, are all necessary so we can have a viable project. Otherwise, it's a tough lot. We don't have to go any more into that. So I thank the board for its consideration and its courtesy over the past few months. Certainly hope we get an affirmative vote. Thank you.
I do have a question for our professionals, and possibly you may know as well. The property lot size and shape, just need to confirm that it was not self-inflicted. This was not subdivided by the current owner, and he didn't create the hardship on himself.
This has been a standalone lot for a considerable period of time. Well, I think long before the present owner took title to it. Yes.
Right, I think first night's testimony, the owner testified that he bought the property hoping to be able to do something with it. So I created it.
I needed to hear it again.
Now it's up to the board to discuss the matter, and if someone wants to make a motion, that's okay too.
I wouldn't mind discussing it before we vote. There's no objections?
Absolutely, I agree with that.
I think you'll probably be able to figure out the way I'm going to vote on it. If this were a conforming application, there'd be nothing to argue about. Applicant has come and asked for a significant number of variances. The municipal land use law provides us guidance. And I think the planner did a good job. He tried to justify 2 different variances, a C1 variance, which is your hardship variance, and he testified as to the narrowness, shallowness, or irregular shape of the lot. The hardship was not self-inflicted, and there was no way out. There was an adjacent property that the applicant could acquire to mitigate or eliminate the variances. So he fulfilled one of the criteria of the C1 variance. The other criteria they're called the negative criteria. One is no substantial detriment to the public good, and the other is no substantial impairment to the intent and purpose of the municipal plan and ordinance. I think the 2 primary objections that were heard at the time were relative to providing adequate light, air, and open space. The mass of the building was considered by some board members and the public to just be too massive and out of character. I think the other one was the utilitarian design of the building. The municipal land use law seeks to promote a desirable visual environment as well. I applaud the revised design. I think it satisfies my concerns relative to the negative criteria. The planner also testified relative to a C2 variance. It's a flexible C. It's an alternate way. He tried to cover both, kind of a belt and suspenders thing. Some of the criteria you have to look at, the variance is needed for a specific piece of property. That's true. They testified this property has been on the market for 8 years. Hasn't attracted a lot of interest. There was testimony by 2 people with accounting degrees and development experience that relative to the minimum building size necessary to make this project feasible. The second criteria is the variance advances the purposes of the municipal land use law. And I look at a couple things if you look into the law, and you can pick out things. Encourage the efficient expenditure of public funds. I think this is an efficient application. It's low impact, provides for the cost-effective use of the property, it brings in tax dollars, and it has a negligible demand for public services. I think the question came up about economics. Was that a criteria or not? I don't believe it's the overriding criteria, but it is to be considered. We consider it in our master plan when we seek to achieve a balance of municipal land uses, when we seek to bring in ratables. In terms of looking at what he can put on the property, you of course consider economics. You wouldn't expect them to put in a whole bunch of improvements to build an ice cream stand or something. So I think economics is certainly part of the consideration. The municipal land use law talks about providing a variety of uses to meet the need of all citizens. We heard testimony about the lack of climate-controlled storage in area. There must be a market for it. I believe there's a market. I think I heard testimony we had to go all the way to Hackettstown if we wanted to find one. Preventing urban sprawl. This is an infill project. It's part of the Highland Center. It's in the existing highway business zone. It's in the existing sewer service area. There's no off-site improvements. So I think it does everything it can to prevent sprawl. Promote the free flow of traffic. There's a small traffic impact. There's been measures taken in terms of controlling turning movements out of the site and so on. I think it promotes that goal of the municipal land use law. Desirable visual environment through creative development techniques and good design. Again, I think this revised design removes my concerns relative to that. I think this does promote municipal land use law in that respect. More efficient use of land. Again, more service, less parking and impervious. So I think it satisfies that criteria. The last one, somewhat subjective. The benefits of granting the variance would substantially outweigh any detriment. In my opinion, this application, as eventually presented, has benefits that outweigh the detriment of granting these variances. So those are my comments.
Thank you, Joe. And I'll follow up with that, too. We heard from the objector last time, from the architect, which I believe had some very valid points. I'm happy to see the application come back to the point where the architect or the objector no longer has to present themselves, and their objection has been removed. So again, kudos on working together on that issue. My big thing that I was concerned about was the traffic. To my satisfaction, I think you have proven that this use will actually present very little traffic. And I don't believe there's a lot we can do based on the geometry of the roadway. We can't fix that. It's not ideal, yes. It's a little dangerous, it's a little complicated. I agree with all that, but I don't believe there's a lot we can do, and I believe we did what we can do. We talked to the chief of police, and he gave his opinion. That was addressed. The last thing I want to bring up which I just need to hear that the fire chief has looked at this and he has given his thumbs up on this one.
Yes, I can address that. I don't know if the fire chief himself or herself has looked at it, but I did forward to the board's professionals, I believe yesterday or Monday, just very recently. The fire department did review it. They approved of the plans. Their only question was, what size would the dumpster and the enclosure be? That was provided to them a little over 2 weeks ago, that information, and we haven't heard back. So we're assuming that it's closer to that.
And that was their only area of concern?
They actually said we approve of the plans.
Yeah, I can read it off to you. There's an April 11th email from Kevin McGuire.
I forwarded that to all the board members.
Okay, then we're good. Thank
I
you.
read it, and I wanted to make sure there was no further follow-up, so...
Yeah, that's the last, Tom, unless you heard something today.
Okay. All right, thank you.
So, yeah, it doesn't appear there's any issue.
I thought it did leave it a little open, because even though they approved the plans, they were concerned if they would have access. But if they haven't followed up further...
We provided the dimensional information that was asked for over 2 weeks ago and didn't hear back.
Okay.
Have to assume it's satisfactory. You don't have to assume.
We don't have to, but they're not here to say otherwise.
Exactly.
So...
I just want to ask our professionals, because I haven't heard from you guys based on the new plans, if there were any concerns on our end or something we should be looking at that maybe we're not.
Well, from my perspective, the improvements to the building have been significant. I think they've done a lot to produce a building that's actually a much higher standard than what I've seen go into most self-store buildings.
Mm-hmm.
And the fact that they were willing to go to the basement, which I've now learned to read the township definition of a basement instead of assume, I think that was a significant change that allowed them to make the pitch. I would also say that in discussing, the intensity of use on the site, the one thing that applicant did comply with is the impervious cover and building coverage. So even though he's on a very substandard lot, he hasn't put a building on here that's technically larger than what he could put on that size of lot. Now, it doesn't meet the setbacks and all that, but bottom line is it is in balance with the town's ordinance as to intensity. And quite frankly, from my perspective, you couldn't get a use other than maybe a furniture store that could generate less traffic and fit on this site better than the one the applicants proposed. So I think it's a very well thought out project at this point. And for such an unusual and difficult lot, I think they've done a pretty good job on it.
Great, thank you.
I would just augment what George said. I think the applicant should be commended for going back to the drawing board after the last meeting and revamping the entire architectural design and coming up with a much more attractive building that's more in scale with the surrounding uses and buildings in this area. And I echo what George said. I think absent maybe this lot being merged in with one of the adjacent commercial lots, and we know that's not going to happen. This is really probably the best use for this location, given the low level of traffic and the quietness of this particular type of use. I would commend the applicant and their team again on this particular project, because every step of the way they did work with Mr. Ritter and I on solving problems and changing the design to better fit this particular use into this neighborhood and onto this particular site. So I think they've done an outstanding job, and I do believe they've proven their case for the various variances that have been requested under this application. So from my perspective, my recommendation will be for the board to approve the various variances that have been requested, design waivers, and the preliminary and final major site plan approval.
Thank you.
I'll limit my comments to the legal side of things. I'll echo what Mr. Pryor said and what my fellow professionals have said. I think the applicants made a compelling case for the variances that they are seeking and the whatever waivers are required. If this use is not approved, I don't know what this lot could be used for, and I would hate to be put in a position to have to defend the denial of this application if, in a court of law, if that's the way this board is to vote.
Thank you. Any other questions from the board or discussion topics?
Just one last thing, and I know everyone's saying the same thing. You guys did a great job of reworking the design and everything. I was held up a bit on the setbacks and how you couldn't clear any of those variance requests. But being as it's a non-conforming lot, squeezing this in there and matching the aesthetics of the neighborhood, I just hope, as a board, we don't set precedents. Somebody doesn't come in and say, oh, well, you approved 6 variances on that project. Why can't you approve 6 variances on my project? So, obviously, we're not setting a standard. This is a non-conforming lot. This is a unique situation. And you guys did a great job.
No changes were required because of the building geometry as far as the drainage or the detention basin. That all stays exactly as it was before, correct?
I think it's time for a motion.
I'll take a motion on something.
I'll make a motion to approve this application subject to, and we didn't discuss the conditions, Paul. Are there any,
Yeah, I think it would be in accordance with George's last letter, my last letter, and in my letter I have suggested conditions on a lot of administrative issues, bonding, permitting, things that are alike. I think we would condition the approval on the site plan being revised to, I guess, be consistent with exhibits A15 through A23, I think it was tonight, or A22. A22. So Mr. Decker would have to revise his plans to be in sync with all the work that Mr. Coleman did, that he presented in these exhibits tonight.
And it would be subject to any stipulations that are in the record that were made by the applicant during the first of the hearing. This has gone over several months, and it would take me some time to go through my notes, but it's part of the record. And if there were any stipulations, they will be included in the resolution as conditions as well.
So then that is the motion.
I'll amend my motion to approve this subject to the conditions in George's most recent letter, Paul's most recent letter, and Mr. Spacero's comments.
I'll take a second.
I'll second the motion.
We have a second, and as a discussion, I would, between ourselves, I would ask right now, so we know, the applicant doesn't have any objections to that letter from our engineer on the stipulations, and that way when this goes through, it's
They
good.
would have been jumping up before this.
Yeah, I assume they would, but I want to be sure.
It's just like jumping off the altar at this point.
I needed to be sure.
Yes, thank you, I appreciate that.
And we will do a vote.
Okay. Members Correa,
Abstain.
Fitzsimmons,
Yes.
Fox,
Yes.
Pryor,
Yes.
Schneider,
Yes.
Wolf,
Yes.
Mayor McKay,
Yes.
Vice Chairman Rachesky,
Yes.
Chairman Johnson,
Yes.
Selectman Turner. Yes.
Congratulations.
Thank you. Thank you very much.
Thank you very much, guys.
You want these here on the patients?
Oh, yes, I can get it. Remember
It's a real pleasure working with this board. All of you very, very much for the patience, multiple meetings, but because compromises, and you compromised, we met with Larkin, he compromised, we did what we had to do, and we'll make it happen. Thank you very much.
Thank you. Thank you.
Good night, folks.
The only way you get overturned is if you come up with an unreasonable decision. And if you can state your reasons and lay them out, you really put yourself on solid ground.
I'm not going.
So let's try and do that.
I was by all the time, it's so tiny.
I agree with you.
That doesn't look tiny.
I don't know how.
Does it look tiny for you?
No, I've been involved in this all the time.
Yeah, I didn't know that.
Okay.
Next.
Next item is the terms of Ken and Carlos. We just want some clarification on that. They are the mayor's appointment, so Tom, do you have clarification on the terms of these two individuals that we can settle on and get it into the record?
I don't know what you mean by, I mean, I think, as I recall, I appointed Ken Fitzsimmons to fill the unexpired term of Facillo, which expires in December of 17, according to my notes.
That's correct.
Okay, and
There was
then,
a question by Member Ochesky, he wanted clarification, he thought Donna was the unexpired term, but it isn't, it's Ken Fitzsimmons. So I just wanted to make it a matter of the record.
now Donna replaced Van Vliet, according to my notes, and her term expires in December of 2020.
Apart from the fact that Gary's irreplaceable.
He is.
There he is. So our question has been answered to satisfaction. We can get this into the... No? You have another one? So Beth, we're good on our terms?
Yeah, I just, like, again, I wasn't prepared to answer Peter's question, so I looked into it and put it on the agenda so that you all were very clear as to who took those unexpired terms.
I think it's important to be clear, so thank you for bringing that up, Beth. Appreciate it.
And so my position still is that if somebody's not here, I can go.
That's correct.
Your position hasn't changed. And then that checks out for Carlos being on the end of 2018. Does the math work? His is 18, correct?
He replaced Garage.
Okay.
Yeah.
What we're going to do is a little modification to the agenda. We're going to push the Highlands Master Plan reevaluation to after executive session, being the executive session to me has a higher priority. And if we have time permitting afterwards, we'll continue the Highlands. If we don't, we'll push it back to the meeting following if there is time for that. So right now, we'll take a 5-minute recess to clear the room, and then we'll start our executive session.
So we just need a motion to go into
So,
executive session.
motion from,
Who made the motion, Peter?
we have
I made a motion.
Peter is the motion.
Who seconded? Okay. All in favor?
Aye.
Eric, we're all out in the break, right?
5 minutes.
Yeah, take the bathroom break.
Keep it at 5.
Executive, not adjourn, we'll continue in executive.
Reconvene.
Reconvene.
Anybody there?
Nope.
They're gone, all right.
Not a one?
All right. Motion to come into regular session.
Do we need a motion for that?
Right, you made
All
a
right,
motion.
we're not...
We're already in it.
You're in.
All right.
So seeing no public outside our doors, we continue.
All right, based upon discussions in closed session, I would ask someone to make a motion as to whether or not we would authorize Mr. Carbone to make application to the appellate division for an award of counsel fees.
And I'll make a motion, we do not authorize Mr. Carbone to pursue his recommendation. I told you that in closed session.
So again, a yes vote is...
No.
Is not to go after...
Not to go after.
Is to... Correct.
Yeah.
Got it.
Not to go after.
So we're all clear.
Second?
Drumfoff seconded.
What?
Thank you.
Wait a minute.
Eric made...
I didn't understand that, so would you please repeat that? Because they were talking, I'm sorry.
Joe, can you say it again?
The motion...
Yeah, I gotta make sure I don't get too many double negatives.
All right, the motion is to, in simple terms, is...
To advise you to tell Mr. Carbone we're not interested in him going after the plaintiffs.
That's correct.
Is that's
the motion.
I'll second it.
Wonderful.
So we have Joe and then Tom, you're second.
2 meetings are...
So this means a yes.
We're like buddies now, you know?
What's going on here? All right, so we've got the motion. I think we're...
Second,
We-
roll call.
Yeah, members Korea,
Abstain?
Simmons,
Yes.
Fox,
Yes.
Pryor,
Yes.
Schneider is absent. Wolf,
Yes.
Mayor McKay,
Yes.
Vice Chairman Archesky,
Yes.
Chairman Johnson,
Yes.
alternate Stockton. Frank.
Yes.
Thank you all very much. The unanimity is...
Unanimous there.
We're getting warm and fuzzies here, everybody's agreeing.
Well, let's see.
Right, what do we have left, Eric?
All right, time permitting, we have to go over some of George's things. I'm just going to check it real quick. I think that's the last on the agenda,
That's it.
besides the announcement, which is already taken care of because it's on the agenda.
And there's no public left.
So, since it's only 8:40, I suggest that we go over one of George's master plan areas and
At the board's pleasure.
so I don't have you basically had a list.
I'll start. I'm just saying it's at the board's
No,
pleasure.
I don't have,
If they want me to go, I'll go.
we want you to go, but I don't have a list in front of me, so
I do.
it's on you.
Yeah, that's all right. Yes, to get into a discussion, if you remember, we put together a report a while back that made certain recommendations for your consideration in terms of possible rezonings, changes to the Highlands Center regulations as part of our conformance with the Highlands. And there were 7 or 8 recommendations in there. One of them, of course, is the ROM district, which we're not going to discuss tonight. But there are some that I think are relevant, and we can get a discussion going on them, I think, with the board. And so I put together a letter back in March, around March 17th, listing about, well, how many? 1, 2, 3, 4, 5, 6, 6 that I thought might be worth discussing. So I'm going to try to work through the ones that hopefully tonight that we can get a discussion going and maybe even resolve some of them. One of the recommendations in the report that we put together was whether or not the board wanted to consider developing what I'll call a public use zoning. One of the things that the township does not have is any designation of lands that are owned by the town and lands that are owned by the school district, the county, recognizing them as public uses. They all fall under your current residential zoning districts or whatever they're in. And it's not unusual for towns to actually create special districts that deal with public uses. That is to say, township, county, state, federal properties. And usually what those ordinances do is essentially allow those uses to use their properties as are consistent with their charter. In other words, the school district can go in and make improvements to their building. The township can do things on their township property for maintenance buildings, whatever, parks. And it sets them aside from the standard zoning regulations, that is to say that they're in the R3 district and are non-conforming and that kind of thing. It also tends to address what happens if the town wants to liquidate some of these properties. Say that a town, through receivership or whatever, gets a property back in its inventory and then later tries to sell it or unload it. Essentially, the ordinance would dictate, as an example, some ordinance would say that if it's a municipal property that's going to be sold to a private individual, it would have to be, when it's sold, it would assume the zoning district within which it's located. In other words, it would just be transferred into that district. Or if it's on a borderline of 2 districts, it would assume the zoning of the most restrictive district, in other words, so that whoever was buying it knows what he's getting. And if the township council or the board wanted to change it, then they'd still have to go through the process of changing it to whatever zone they feel is appropriate. It would also exempt the township, the county, the municipal governments from making site plan applications, but would require them to inform the township council and the boards of what they're doing. In other words, you'd have to come back informally and make a presentation to the board and let them know what you're doing, but it would be more for information. That's one of the questions that's raised here, whether or not you want to go through the town, designate your parks, your school sites, other municipal properties, and actually zone them as public uses, rather than leaving them embedded in your residential, commercial districts, and leaving a cloud as to what their use really is. It's something to think about. The various towns that I've worked in all have public zones, and it seems over the years to work very well in the towns that I'm in, and the main purpose is, as I say, if they decide to sell a property or move it, then at least it's very clear as to what the zoning has to be if the township fathers decide to relinquish control of a property, or if something changes, how it's to be handled. So that's something to talk about. That's something we thought might be useful in this go-round of the master plan revisions, to think about whether we wanted to do that or not.
Okay, can I ask you a couple questions on that, a couple of hypotheticals? Let's say we put the municipal building in a, what do you call it? Public use.
Yeah, it's public use.
I really don't get it. What are we zoned now, residential?
Yeah, it's in a residential district now.
So if we abandon this building, the guy's in a residential district. If you put it in a public use zone and then say it reverts back to the residential district, I really don't see the difference.
Well, what it does is allow you, it lays out that, one, if the township wants to do additions, wants to do improvements to here, they don't have to do a formal site plan application.
Do we have to do now?
I don't think you'd have to. Many towns actually require their own municipality to abide by their own ordinance.
I know, and others exempt them. I'm just trying to think it through. I mean, this is one way, there's other ways, right?
Well, I'd say the public use zones are the way most towns in New Jersey handle it right now. The other thing they can do is state that certain types of improvements, I'll give you one example. In Chester Township, we basically say that a municipal property, if they go to put any type of outdoor storage on it, it has to be so many feet from an abutting residential use, or they can't do it. So there's a restriction on themselves.
What's the park zone now?
There isn't any.
No, I mean, what is the park zone? Residential?
Yeah, all your various municipal properties and parks are under the residential zoning or commercial, wherever they fall. I didn't take the time to actually map where they all are, but they fall under the current zoning.
It's an R150 and an R5.
Well, I was around when we did that park. Did we go before the planning board?
I don't remember, to be honest with you. I don't know. The park.
I'm trying to think this through myself.
The other aspect of it that you can look at is if you want to, it also puts the public who buys and sells houses where the public properties are. It tells them where the stuff is in town. In other words, they can look at the map and actually see it.
Now, what about properties like, open space, that would be deed restricted? Something that uses government funds, you get on your green space, properties and stuff, where you can't then sell it and turn it into residential.
No, but
it has to be open space forever.
It just points out what it is. Like if it was a county park, a state park, or a town park, it would come up as public use. It would be a park.
Right.
And the ordinance would be basically saying that you can use the park for park purposes. In other words, the way the ordinance is established is that there's supposed to be uses applied to those that are consistent with the intent of the owner, the park. It's true, some can't be sold, some can't. I mean, as I say, the one town I work in, we have the Black River State Park. It's probably 700-800 acres. That's a park, but it's designated as open space, as a public zone. And the other advantage that I see is it tells property owners what they're next to. I mean, they basically can see where the municipal facilities are. I'm just suggesting that it's something you want to think about. If you don't want to do it, you can leave it exactly the way it is.
I want to think about it, I want to understand it all.
Are there any negatives? Are there any negatives to doing it?
Not that I've seen over the years in the towns that I'm familiar with. It has actually, you could argue, work in favor of the residents up in Chester Township when the town decided they were going to do something with a municipal property, and they wanted to sell it to a guy for a use that wasn't consistent with the zoning on the
Well, how
side.
about the Delaware Park School? How did that go?
Well, that's the same arrangement
Yeah.
there. The zone was changed. In other words, if the Delaware Park School was under a public use zone, it would have told you what the base zoning district had to be when it was sold. And if somebody wanted to change it...
But he was already in that, right?
What?
The Delaware Park School was already in that residential district.
Yes.
And he had to go to the Board of
Well, he had
Adjustment,
to get a use variance.
Yeah.
He did, because he was totally changing the thing.
And that wouldn't have changed that. It wouldn't have changed, if this was a public zone, it wouldn't have changed the fact that he had to go get the use change, right? It wouldn't have made a difference.
Well, no, except it would have started
No,
out
it
by
would have
saying,
reverted
it would have reverted to the surrounding zoning district.
But he was already in that.
But he was already there.
He was already there.
That's my point.
Yes.
And he wanted to go multifamily, which wasn't part of that, so he had to go to the Board of Adjustment anyway.
He would have had to do it anyway.
So I'm trying to think through the... I did want to answer John's question real quick. Green Acres is horrendous. If you get Green Acres money, you're giving away your rights forever here. And as far as I know, the town has always refused Green
The
Acres.
environmental committee, remember, we want to promote open space, green acres properties. We want to create
But
bandways.
as a governing body member,
buffers.
you hate to give away your rights for all history. And someday you may want to lay a sewer line through there. And you go through as much trouble getting approval for a sewer line as if you wanted to reclaim the park. You can't believe how that delays projects. So that, as far as I know, there's no Green Acres property in Lopat, and it's been discussed, and it's been discarded a couple
Well, no,
times.
and I know, and that's kind of where I'm going. So then, and I'm wondering, if it's hard to get board or township or the populace to commit to that long-term Green Acres commitment, could we utilize this public use zoning to kind of start to carve out greenways and things that might be a compromise to Green Acres?
Well, no, this zoning would not be used to create parks. It responds to what is owned.
But once it's all laid out on the map and say, oh, well, here we have all these public use properties, and, if we could acquire this property, look at that, we would connect these, and we'd have it even longer.
Well, there's a difference between open space planning and your master plan, and implementation through development applications and that kind of thing, and zoning for public use. The type of zoning here gets applied to properties that are already under the control of government, either the town, the county, the state, the feds. That's what it gets applied to. The planning of how you link your parks, how you develop your parks, is not part of this zoning per se, because this actually goes on the properties that are actually in use and owned by a public agency. Planning links park planning, that's part of your master plan, and can be included in a master plan in terms of where you want the paths, how you see them linking up, and the things you're talking about, picking, well, here's a park, well, that would be part of the planning study that would actually be in the master plan to say why you want the links. And then if somebody comes in with an application that happens to impact one of those proposed paths and areas, the board may not get it, but the board can clearly ask for it as part of, an application. I guess the best way to describe it is that in Chester, we have an open space plan that had a series of trails on it, and we acquired through the development process and set-asides as part of the development of those parcels, we got trails that amount to maybe 6 miles of trails. That way, it took 12 years, and working on it. Since the Highlands come in, it's much more difficult because nobody develops, so you have very little control over that. But there's two different things going on there. What you're thinking about is a master planning process. This is a zoning process that would just identify these different things, pull them out on the map, and it's really a way to just say how they're going to go back and be used. And if you, as an example, if you want to prohibit certain types of activities, it can be put in here. Like I said, you can't put outdoor storage yards, warehouses within so many feet of a house. That would stop your municipal government from actually putting it without going through a process of expanding next to a home or something and doing something that's inconsistent. Now it comes down to whether you want to put those handcuffs on you. The town that I work in, that I know the code, was willing to do that. They trusted themselves to put those prohibitions right in the public zone so that the government couldn't arbitrarily stick the stuff on the site.
Or I'd go back to our public works yard. Have you ever been down there?
Well, I know where the one is. I don't know if I know where all of them.
There's all kinds of things go on there, and they do what they have to do. I would hate to put handcuffs on them. One day you don't have salt, next thing you need a salt bin. I don't know.
Well, it's a question. You don't have to do it. I'm just saying that's some of the purpose.
It could also work the other way. You put these things in here that make it easier for them to do what they need to do.
Now, I always thought that government is here to protect working for the residents and for the citizens, and our goal should be to be looking out for the benefit of the residents and not necessarily for us or for the town. So I don't have any objection of limiting ourselves and making sure we comply with everything we should comply.
It seems like the big advantage of it is just the knowledge base. You could look at a map and see, well, these are your public areas, and this one we shouldn't worry about, is the DPW. They need to do what they need to do, but all the rest of them, you want to keep them public, but the knowledge base is there, so you can see what you have as far as public property goes.
Well, that's what I always felt, that it also tells the surrounding owners of private property, well, it gives them on notice what's there. And I'm not talking about the guy that lived there for 35 years and knows what his neighbor is. I'm talking about when they buy and sell properties, it gives somebody a way to look at a master plan or at a town map and be able to say, oh, well, there's something public going on next to me. What is it?
By creating a public use zone that then might take properties and dot them all over, is there anything would we adversely affect people adjacent to those properties? Like sometimes if you're adjacent to a different zone boundary, like are there different regulations?
No, we've never had that problem because a public zone doesn't set buffers. It normally doesn't. I'm not saying it can't, but no, it wouldn't have an impact on the neighbors other than putting them on notice that the public owns the property. And they would have to be updated periodically, like the zoning map always tends to lag behind what's going on. I mean, oftentimes properties will be acquired through tax liens. They'll get them back in the system, then the town has to decide whether they're really public or if they're going to sell them, that kind of thing. And sometimes parks are acquired and, the zoning map doesn't get updated for a year or two, but you just try to keep everything up to date as you go forward. And like I say, the biggest help, I think, is it puts people on notice. It lets them know what's there. Usually, in the master plan or on the zoning map, oftentimes you note that where the schools are. It's a public zone, but it's labeled school, municipal building. It's actually right on the zoning map. So people can look at it and know what they're looking at.
That's right, but just thinking about it, Eric, you're right. Now, if a resident wants to know right now what's public, they would not, how would they figure out? Besides, unless there's a school on it or this, but all the other properties which are not developed but are owned by the town, how would they know?
We have an inventory of them.
Yeah.
You'd have to come in here and look at.
Yeah, it's just that this puts it
You'd
on
have
the
to
zoning.
do work either way.
Huh?
You'd have to do work either way.
Well, you could, except if it's on the zoning map, it's a lot easier, that's all I'm saying. It's a
You
day.
still don't know what's there. It would say public zone, right?
So
I
George,
don't think Lopatcong Township's ever sold any public property.
Well, then there's those things we get in tax sale and then we sell again, right?
No.
Yes,
Yeah.
we have put liens on properties
You
and we
put liens?
foreclosed on them.
Right, but you never sold any.
Not yet.
That's right.
But we could.
so George, hypothetically, let's,
Theoretically, I'm saying this township has never sold municipal-owned property.
How about the land swap with Ferrucci? That's how you got your park.
We bought that.
No, that was a sale.
We bought that. I think, yeah.
We had property and he gave us property. His property,
He gave...
his property was used to complete
He
the
kept
park,
2 lots.
but they were conveyed from the town to him.
That's right.
Yes, after the whole transaction
Yes.
took place.
7 years
they
later
were
for $1
conveyed
each.
back to him, yes. And that was in the original agreement to do that.
so George, let's say hypothetically, right now, we don't see a lot of negatives with this, there's only positives.
Yeah.
The next step, what would the next step would be? I guess it would be obviously identifying them so we can all see them. And, you know, like Joe had a great example there. So let's say you identify all these areas that could become zone public use. If there's one of those spots that we think has a huge negative effect, could we pull that from the public and not change it to public use?
Well, yeah,
Doesn't, as far as, don't you have to create a ROSI? Didn't we have a list?
well, but that's for the parks.
Yeah.
That's for the parks. There's different processes going on here. This is really doing nothing more than showing the properties that are in municipal ownership. If you have a lot that you put a tax lien on and flip it, I don't think that would ever end up as a piece of open space.
The municipality owns a lot of lots.
They're
all over the place.
Okay, but I assume that the zoning that's on those is the zoning that stays. In other words, you're not turning them into a park, you're not turning them into the municipal warehouse or whatever. And those wouldn't show up on this map. What would show up on the maps is the stuff that is really municipally, state, county, or government owned, and the intent is that's how it's gonna stay. Unless something unusual happens. But I mean, it shows up, and I see it as more informative. It also, as I say, if you want to put some restrictions on how these properties are used, that's something that could be considered too. I will say that most of the ones I've been involved in have virtually no restrictions on how the town or a municipal government can handle them.
But you said that they're in use. Didn't you say that before? That the
Yes.
property would be in. So if the township was given a lot in lieu of foreclosure or something way back, and it's not doing anything with it.
Well, if your intent is just to flip that out as another lot in the zoning district, it'll never show up on this map.
Yeah, that's what I mean. Okay.
If it's a town park, it would show up as a public use park. It's not all that significant, other than I think for public record and informing people, it's a good thing to have. It tends to show people how much green you have in the town, which I don't think can hurt in terms of your real estate sales and value. The more you can show green on a map, the better off you are.
I'm thinking out loud, not everything's green. What if you had a municipal dump?
Yeah. Well,
it would seem to me if you create the zone, you have to create some restrictions with it. Because they all become conforming. What's to stop us from voting one night and we create construction waste landfill on.
Well, the purpose of the zone is if it's a park, the purpose is to be used for a park. If you go to change it,
No, but I'm saying as a zone, as a municipal, as a public use zone.
yes.
Everybody's going to be in the zone.
So public...
And all public
and public use.
buildings and applications, everybody's going to be in the zone that the municipality has a facility on. Are there any restrictions on that zone?
Yes, the ones you want to put in. The only ones I'm suggesting that I've seen work is setbacks in terms of types of uses. In other words, it just comes out and says if you're going to build a municipal maintenance facility, I'm not talking about the ones that exist, we're going to put a restriction on here on ourselves that we're not going to put them within X feet of a guy's house, or we're not going to put it within so many feet of outdoor storage yard. It's just the restrictions you're willing to live with. And then the rest of it is saying that they can be used for purposes that they're designed for. In other words, park uses can go in parks. I've never had a problem with it in any town, but it also makes it clear that these do exist and can be improved for the uses the county park can do a county park project, that kind of thing.
Your other towns.
Who controls public use?
Well, the government agencies, in other words, the county park system controls the county.
I'll take with a fact line. If we say across the street where the church is at, with a vacant lot, and you're saying it's a public use.
Well, the church wouldn't be.
No, I'm saying it's a vacant lot.
Yeah.
Owned by the township.
Okay.
And you're saying it's public use.
I would say
now,
that.
Who controls the use of that property?
The way it would go into a
If 25 kids come in and want to go over there and start putting skateboard park in, you say, well, this is for public use.
No, the question is it a park? Is it a school?
It would have to be designated.
It has to be designated that on the zoning map, so then that becomes the use.
They just can't walk.
It isn't just an open piece of ground that you just all of a sudden declare it's public or use. They're labeled.
George, do you have one of these in writing from another town? Maybe you could circulate it around?
Yeah, no,
I think that would give us a good
I can
flavor
send you
for it.
around a couple examples of how towns have handled it.
Yeah,
Couple would be good.
Yeah,
Especially towns that might handle it a little different way.
Yeah, well, there's.
I think that's what we need. We need to be able to see what it looks like.
Okay, no,
touch
that's
it.
good. It's just whether, you have some merit, I'll go ahead and dig a little harder for it and send some stuff out.
Okay, thank you.
So at this point,
My mind's open once I understand how it...
So we're showing enough interest, George, where I think we want you to gather up some more information for us and show us some examples of it.
Okay.
George, I have a question.
Carlos, go ahead.
Do you know like an estimated cost for this township to change all these properties and put them into this public use?
Well, they're already in the public use. All we have to do is identify them and put them on a zoning.
It's part of the rezone, the master plan we're working on.
So it wouldn't cost anything to the town?
Well,
Not really.
it'll cost virtually nothing. It's more just sitting down and identifying what properties you have, where they're at, and putting them on the zoning map. And then, which is part of this process, making a recommendation as to guidelines for a zoning change. In other words, not the actual ordinance, but just what's intended by doing it. So no, it wouldn't take much, and then get it on the map. And I can get a couple examples. You can see how a couple townships have handled it and see how you want to do it. Like I say, almost all the towns that I've worked in have a public use zone, so it's just something to think about. It's not mandatory.
We don't need a vote to...
No,
He just continues. Okay, thank you.
Things are going so smoothly, let me just throw something in here. The Land Use Act does not specifically exempt from municipalities and municipally owned property from zoning, or the requirement to secure site plan approval to use property for a particular use. Most towns will simply say, you don't have to come into the planning board, or if you do, it's sort of a courtesy review. I would recommend to be on the safe side, because I'm in a situation now in another town where a member of the public is objecting to an addition to a police department building, saying they're not exempt, they need site plan approval. And the truth is, they do. The planning board doesn't want to deal with it. The town does not want to put itself to the expense of putting a plan together. I think it would help you to give you the flexibility that you want and need, if it's something that you want, to exempt the municipality from the need to secure site plan approval for public projects. Something you may want to think about.
Yes, and as an example, in the towns I'm most familiar with, they're exempt from site plan approval, and they are only subject to review by the township professionals and review by the township council if they deem it necessary. I mean, it makes it clear that they don't have to make a formal site plan application to the board.
Nothing prohibits you from creating that exemption, but in the absence of an exemption in your ordinance, the town's property and the use of that property really is like everyone else.
Why should it not be?
I'm sorry?
Why should it not be that? Why should they not have to get the proper application, and why should they be exempt from anything?
Well, one of the problems you'll struggle with is there's no design standards for, probably, and I'll say this, if the police station is in a residential zone, there may not be any design standards to address what the police station's doing. I mean, that would make him subject to a residential zoning district or needing, all sorts of relief to do their project. By exempting them but allowing the township officials to look at it, one of the things that isn't even in our ordinance in Chester but is required is that the township meet all its stormwater regulations. Every township project has to be designed in accordance with the township stormwater regulations.
How's Lopat doing it?
What?
How are we doing it? What are we doing?
I don't have a clue, to be honest with you. I'm bringing this up as something you might want to think of.
We're talking about all these towns around us, but how we don't know?
Well, you don't have a zone, so I don't know how it's handled here.
I don't recall a public project in a long time, except for the new pump station, which, Beth, I don't think that went before any boards.
No.
Well, they wouldn't normally have to.
That was a replacement, right?
No, but it was moved.
New place.
It was a new place.
It's just why, if you want some kind of oversight, but not to the level of planning board review in terms of site plan, leave it with the governing body, as George recommended, to review it and have your professionals review it if you deem that necessary. I think that way there's some checks and balances, but not to the extent that normally would apply. It's also a cost saving. Absolutely.
Yeah, but you do need some, because I think as an adjacent property owner, if you're next to a municipal lot and they're changing something or adding an addition, I think you owe it to that adjacent property owner to make sure they don't object or have any concerns.
Yeah, but it also leaves, this ordinance that I'm most familiar with also means that an objector can go back to council and make his case, which may give him a voice that is listened to. Meaning, if he goes in front of his township council and says, "What are you doing to me?" they may listen if they think he has valid points.
Assuming he finds out about it and trying to bring up his concerns, they're already building it, they're going to...
Well,
there's no notice requirements, right?
No.
So at least the planning board, you have that protection.
It's something to think about.
Well, I'll get some examples and you can take a look at it, and we won't take it out of the recommendations, at least not yet, and I'll let you look at what some other towns have done.
Excellent. Thank you.
All right.
George, you want to do the next one?
Sure. Let's pick another one that might be fun. The Planned Unit Development Overlay District. This one is a district, I don't have my laser here. It's a district that includes a good chunk of your industrial zone. It was adopted, I don't know, 6-7 years ago, with the idea of encouraging the redevelopment of the Ingersoll property and also encouraging putting together assembling larger parcels and doing mixed-use development. It's an overlay district that includes the Ingersoll tract. It includes the affordable housing site that's under construction on 22. It includes part of the mall, and then it includes all of the industrial zone is in the overlay district. And what that is a district that gives density bonuses and impervious cover bonuses for assembling projects up to at least a minimum of 50 acres and doing mixed use. The idea was that we could get some mixed residential, commercial development. It was originally done with the idea of encouraging the redevelopment of the Ingersoll project into a mixed use project, or possibly getting some assemblies in the industrial district to do larger, more efficient types of development. Zero interest. We haven't had one person come in and apply or try to assemble anything. And now with the Ingersoll project being covered under the redevelopment plan, the largest single project that we had is gone. That's covered under the redevelopment agency. And most of these tracts now have various uses on them. That'd be almost impossible now. Well, they're still where the solar is. If that was torn down, you have a large enough acreage. But essentially, there's very few projects that can be assembled anymore. And my sense is, it just makes no sense to leave it in the district. It encourages no one, and I think it would be a much simpler and a cleaner ordinance to just take it out.
And what's the overlay district called?
Well, it's I don't know what we actually call it. It's essentially well, I have the actual name back in my notes.
Oh, I thought that was labeled right there, pointing to it.
Oh, I'm sorry, Planned Development Overlay District. It's essentially to encourage non-residential development, assembly of larger properties, and we were hoping to get mixed use, retail, commercial office. We were originally looking at hopefully somebody on the Ingersoll tractor picking that up. As I said, it's gone to a redevelopment plan. The largest property's gone, and our sense is that it really serves no useful purpose anymore other than filling space in your ordinance. And it would simplify a lot of things to take it out. The one part of the planned development district that would be retained is the ability to do a development plan, which is what Ingersoll is currently being developed under. They're able to do a development plan in lieu of a specific site plan.
George, there's another large piece that's next to the mall that's undeveloped. They used to speak as if it was going to be developed for senior housing.
Yes, that's another one of our subjects that'll be coming up.
All right, that's not included in the, this isn't in the overlay zone?
No, it is not.
Oh, okay.
It's outside of it.
Well, we could do that one next.
So anyhow, my sense is it serves no useful function. No one has chosen in all the years it's been here to develop it. Sometimes it's good to edit.
Open space.
What?
Yeah.
Open space, who said that?
Park.
Green acres.
Green acres.
Rossi.
Never get it back.
Well, this has nothing to do with open space. This is development. This is really trying to encourage development.
Nobody wants it, really.
Yeah.
It's all back, it's back behind the mall, isn't it?
Yeah.
Yeah.
But there's going to be a nature center as part of
To deal with.
the deal with Ingersoll Rand. So you're putting a nature center right there along the stream corridor.
Get them defined.
Yeah.
Well, before we get to that, let's decide on the overlay district, and that's my next one. We can jump right into the next one.
So if you take away the overlay district.
Correct.
What does it revert, does it just revert back?
Well, it
to-
stays exactly as zoned. It'll be HBROM,
Okay.
or it'll be part of the redevelopment plan for Ingersoll. And the only thing that we keep out of that zoning was, we have a planned development option in the ordinance, which is what Ingersoll is being developed under. And that would be retained, that portion of it. And that's really nothing but a procedure to get approval of a large-scale project.
So this wouldn't affect the Ingersoll?
It wouldn't, well, no, keeping the redevelopment in there will let them continue exactly as they are. So, like I say, I just think it's a good one to clean up. I don't envision anyone ever taking us up on that again. And it complicates the ordinance. It gives bonuses. Nobody's chosen to ever go after the bonuses. Let's just say it was probably a good idea, but didn't produce any results.
George, were you around when that was,
Oh, absolutely.
and the thinking was, what, just,
The thinking was to try to encourage assembly of larger blocks of ground into a unified plan of mixed uses.
yeah, I always associate mixed use with a town center or something like that.
Well, this gave you the ability to do it. If you read the ordinance,
Yeah.
if the Ingersoll tract under this ordinance could have been developed as a town center.
Well, that might have made sense. You have apartments and shops and...
Well, right. I'm just saying nobody's...
But that was a clean site. That was 100 acres that was...
Well, but this was to apply to basically clean
Yeah.
sites. It was to
The
encourage
rest of
them
it now
to
is a
assemble.
hodgepodge of storage and industry, and
That's why
I can't imagine somebody paying a lot of money to sit next to industry,
Well, that's why I think, quite frankly, it makes no sense to keep it. The original motivation was to try to get somebody to do something with the Ingersoll and maybe something else. But the bottom line is, I think the real purpose of that ordinance is gone. And like I say, I believe housekeeping sometimes is good on these ordinances. If they're not performing, just get the stuff out of there.
What year was that done? Or what year was it implemented?
Do I have it here?
What's that? Oh. When I was one.
Where is my briefcase?
I don't think it's that important.
No, I was just curious how long it has not been working.
It was proposed in 2004.
Okay.
And it was rezoned the following year, 2005.
So over 10 years, we've gotten
Nothing. Not one application. And the Ingersoll property, as I said, came in under its own redevelopment plan, so that's gone. And that was the largest single property. So again, my thought, I mean, you can look at the ordinance, you can read up on it and see what you think, but my guess is to take it out, just eliminate it.
Does anybody object to George's recommendation, or do we want to talk about it some more and get...
No, I have to be honest with you, I never even heard about it, so...
Yeah, it was an overlay to an existing zoning.
Yes, yeah, it won't change the base zoning at all.
And it hasn't worked.
And nobody has taken us up on the bonus.
And it's not like there's any void or vacuum by removing it.
No.
Everything stays the same.
So if we,
It just gets clearer.
so Tony, what do we have to do officially to concur with George's recommendation?
All you have to do is right now, as far as I'm concerned, as a board, if you agree, just, you can say, yeah, yay, nay, and that's good enough, and I'll just work.
One piece of...
Oh, it's one piece, I know, it's one piece of a bunch, but let's get this piece behind us if we all agree that, yeah, it doesn't make sense. Let's just get done with it. So can we just say all in favor, or do we have to do a motion or anything? Just, I'll do it official.
I'd make a motion for him to put it in his plan for now.
To take it out of the master plan.
He's assembling a plan.
I second the motion.
Okay, I understand. I got it.
He's got nine.
All in favor?
Okay.
Wait, who made the motion, Joe? Did you?
Joe.
Yeah.
And that's to take the
I want to make sure I
overlay
Cut the whole
The
motion.
planned overlay district out of the ordinance.
Yeah. Well, it's going to wind up in a recommendation of some sort. We'll see the whole thing
Well-
again, and that'll get approved and sent up. But
But-
for the working document, I
That's
say yes,
all in
go ahead and
favor?
take it out.
Aye.
Aye.
Okay, good. Now,
roll tonight.
we'll move over to the one that everybody wanted to talk about. This is the parcel behind the mall. It's the AARC, Active Adult Residential Community District, that was put back there.
That's the gold one that Carlos just...
That's the gold one behind, right there. Yeah.
Is that the only AARC
Yes.
zone in the township?
Yes.
There's nothing on it for electricity and sewer.
There's no sewer. That's one of the reasons we're going to talk about it. The original idea was to create a senior citizen housing project that provided affordable units as well. It has a mandatory requirement for set-aside in it if you're going to develop it. There's two things that have happened since that's been developed that became very clear. Actually, three. One, there's become a major feud between the shopping center and the property to the rear as to whether they have access to the loop road that serves the mall, which is an issue that still remains unresolved. It was finally resolved with the current housing project that's under construction. That only took 3 years to resolve that. But that's one of the issues. But more importantly, the issue was not included in the Highlands Center designation for the township. And on the Highlands Regional Master Plan, this area is not within a district that they would support providing any sewer service to. The other aspect of it is, it's my understanding that the only way to get sewer in there right now is out of, what's the abutting town? Cohasset. To serve that tract. Now, the difficulty comes that our ordinance is written that there's only two uses they can do, townhouses and multifamily. Well, if they can't get sewer, that means that that property can't be developed, and we're all sitting around here thinking that it's pretty remote that that'll ever happen. So there's several things we could do as a town. We could try to put them into the Highlands Center designation, in other words, go back and ask to reconsider and put them in, which means that maybe they could get sewer. Or we could propose to amend their approval, and we can do this several different ways, their zoning, I'm sorry, not approval, their zoning, so that we could put in there that if they do not get sewer, they have to develop the site residentially at a density that can be supported on septic. The old zoning of that site was 5-acre with a 3-acre cluster. That was the original zoning of that tract. So we could write a clause that just says, if you don't, here's your zoning, if you ever get sewer, you can go ahead and do what we said you could do. If you don't, you gotta do 5 3-acre cluster zoning on the back. Now, there's advantages to cluster on that back piece. There's also issues that we can talk about, but the advantage of clustering is that you might be able to, if somebody did it, you might be able to create open space along your stream corridor. You might be able to actually get some of the open space buffers that I know a lot of people would like to see happen back there. The other way to do it is to simply say, look, we give up, we know it'll never be part of the center, and we're just going to zone it R 3 acres. In other words, just take away the multifamily zoning and just make it an R3, R5, 3-acre cluster zone, which it was in the past. Or if you think because it's behind the mall and there ought to be a recognition of higher density, we could zone it into a residential district like our 2-acre zone or something, because that could still support septic, and put them in that zone. And then the ultimate zone that you could do, which I seriously doubt because the mall's in trouble, you could obviously say, well, that's a spot where we might have a community shopping center. In other words, maybe they should make the shopping center bigger, so you could always zone it into another commercial district. But I also know that that shopping center is struggling, so I'm not sure that makes any sense. So I think it's something, though, we ought to address, because I'm amazed they haven't shown up here and made a case for something on that site, because we have it zoned in a way now that they are stuck with a property that they can't do virtually anything with.
Do we know if the same people own it today that were the ones who were going to build the senior project?
I have no idea what.
No, I don't think it is. I think it's Santini owns it now. He's a former.
I don't know.
George, what access does that property owner have to
the Mall Road?
That's it?
Yes. As far as I know, that's the only access into that property is the Mall Road.
And Highlands does not support sewer?
Well, now, take it back. Highlands does not support sewer on that particular property, just like it didn't support sewer on almost your whole industrial district until we put it in the center. And the reason for getting center designation years ago from the Highlands was to give the town the flexibility to extend sewers, if they have the gallonage, extend sewer into certain areas of the town. And that's why we had it put in the center designation. There's no reason to believe that if you went back to the Highlands now and got that put in the center designation, that if, and I say if because I know all the problems, if there were sewer available, then they might be able to extend it to that property, if we put it in the center. If we don't, I don't think there's a chance, because the Highlands, believe it or not, has that in an agricultural preservation designation.
The sewer still comes from Pohat regardless.
Well, there was originally a chance to bring it up from the bottom, but I think that up from the creek, but I think that was decided couldn't be done.
I never heard that, to be honest with you.
I'm trying to remember when the housing project was approved.
No, Ferrucci came up with the Lock Street thing, and that's the only solid proposal I remember for going down the river. There's a sewer that loops around the mall and goes into Pohat.
That's right.
And that would have been the logical candidate, I think. Otherwise, you'd have to go all the way down to Peabody or something.
What's the recommendation, George?
Do you know how the Pohat property that butts it is zoned?
It's zoned small lot residential, but in the Pohat side. It's small lot. I don't remember the exact side, but it's small.
The smallest lot size that we can get in there and still do septic is 2 acres?
I'd prefer no more than 1.5 acres to 2 acres as an absolute minimum if you're going to put septic on it. I think 2's a good number. Till you get the field in and find a place that perks.
But they haven't come to us to ask for any approval to build anything.
No, I'm amazed that they haven't.
Actually, they tried to sell this to the county for green acres.
Oh, well, maybe that's their way out.
But the county didn't take it. I remember seeing
How much acreage is it, the total? It's hard to...
There's 2 lots, one in Pohat, one in Lopatcong, right?
It's 10 acres, 20?
Oh, it's fairly large. I bet it's, I'm trying to eye it up. I bet it's close to 40, 50 acres.
It's all sloped. They've driven back there.
Well, it rolls down. Right next to the Mall Road, it's fairly flat, and then it drops off in the back.
Do you know what the Pohat side?
Lopat Creek.
Do you know what the Pohat side is zoned?
Residential small lot.
Small lot.
Yes. And I mean small. They have sewer. I mean they're
small lot. What's that? 1/4 acre? Small.
I don't want to mislead you. I'd have to look it up. I don't.
Well, they've got the sewer, so it probably is pretty small.
Yeah, well, it's small. I know that.
A lot of technical streets.
And as I say, the original zoning before it was rezoned to encourage this was 5 acres with a 3-acre cluster. That's what it was zoned. I had nothing. I don't know why it was that zoned, but that's what it was zoned. I suspect it was partially because of the environmental issues.
What's the main difference between a 3-acre zoning and a 3-acre cluster zoning?
It's the amount of open space. The 3-acre zone, you could cut the whole site up into 3-acre lots. if we do what we call the cluster ordinance, they would have to set aside a certain portion of the site as public's the wrong word, as open space that could not be included in a lot. And in the districts that we have now, if it was R5 with a 3-acre cluster, 50% of the land would have to be put in what, for all intents and purposes, would be a park.
So it's pretty restricted.
Yes, if you did it in our mandatory 3-acre cluster to 2, the minimum set aside would be 25%.
Detention basins count as part of that.
You know, George,
So you set aside, I'm sorry, Jack.
I was just going to say that maybe the mall's not doing well, but the outbuildings seem to be viable.
Yeah, they have the frontage. I
Would it make
agree.
sense? I mean, they put a tire center back there, they could put...
Well, I mean, if this was a viable mall, I'd tell you that rezoning it to business use would probably be the smartest
But I'm
thing.
saying those outbuildings are independent of the mall, and they
Yes.
seem to be viable.
Yes.
Bought the property, I understood, and they're separate from they bought it from the mall.
They spun all of them.
Yeah, a lot of those pad sites, the one thing you're struggling with is that if the mall isn't healthy, there's not as much traffic to drive behind it. If this was the King of Prussia Mall, I'd tell you, you could build anything on that property and it would sell as a commercial project.
I understand that, but you go into Panera's any hour, and, you know, it's crowded. There's stores that are popular.
Yeah.
And that's probably as good a spot for a store like that as any.
I have no problem with zoning it commercial. I think it's a difficult commercial property, just given the health of the mall. The ones that are selling well are the ones that face out on the main strip. I mean,
I don't know if they're doing that well either. I've seen Pizza Hut come and go, Sonic come and go. I mean,
Yeah, Pizza Hut was here a long time, and
really long time.
A long time.
Yeah.
And Pizza Hut as a business kind of had an up and a down.
Now, I see a lot of change over on that frontage.
Yeah.
I don't know, you know, maybe the ones there are doing okay, but
Starbucks is doing a lot.
Sonic didn't do well.
What
No,
replaced that?
it's
Pizza Hut was there, what replaced that?
Was it Sonic? Sonic didn't work.
Sonic and then Sonic.
Chick-fil-A was there, or is there?
Yep.
I don't know, to me, George, nothing makes a whole lot of sense back here. I think it's probably a piece of property.
Well, the one thing we could do to give the guy an out is simply leave it zoned the way it is, but put in there an option to develop single family if you don't have. In other words, leave him an option, that's all I'm saying.
The actual building.
You have to put something, and large acre residential,
I don't think we need more family. We have enough family.
well, the alternative is business.
Yeah.
Well, yeah, as I say, business might, you know, if the mall, and I don't know enough about where they are, the heads of these guys at the mall, if they saw that available as a commercial strip, would they buy it and then expand their mall to make it more viable? I don't know.
And considering, with the new development there, maybe some small, you know, do people go and get coffee and whatnot, maybe something would work there, I don't know, I think I would say back to Transbridge, build something there so they could buy these kids instead of coming into the mall.
Can business be supported by separate?
Exactly.
Well, very low density business. I mean, you know, you can play with it, but it's not going to be that intense. They'd have to cut it up somehow.
But what's there not working now, so I mean, maybe business is a good idea, you might get some bites on that.
Something to think about, Eric.
Yeah.
I think it's good farmland.
Sleep over, you know, sleep over.
Yeah, I think it's good, you know, kind of...
Big green acres.
Well, yes, I do.
I know what you want, but...
Well, no, and I like what you said, you know, sometimes by identifying, you know, parcels that we want to preserve and open space, that when a developer comes in and you said, okay, you're going to develop, we can cross you over on this side and you dedicate this to open, permanent open space, you know, we give you this, you give us that. Well, not in this case.
Well, George's 5-3 does that.
5-3 would do that because...
Maybe you could make it 3-2 or something.
Oh, right, you can pick the...
Yeah, we can pick one, so...
But we have different districts.
Yeah.
We have 10-5, 5-3, and 3-2. Cluster, mandatory, you have no choice. And then we have our standard...
Scenic Ridge like that? That was...
Scenic Ridge.
There's no access to that.
I was around,
There's no access to the
Yeah,
property.
because that was a big piece.
when they did that whole deal, it was all packaged, we gave him the zoning on the front.
I think it's almost impossible for a bridge.
We gave him the houses on the front, we actually own the rear of that property, where Scenic Ridge was. That wasn't really a cluster, that was all part of the proposal when all this land got
Well,
swapped.
Scenic Ridge is the one up on the side of the hill. That's a
Yeah.
straight zoning district. I know
Yeah.
which one you're talking about.
And he deeded the rear of that, he agreed at that time.
Yeah, and the water tank or something's up there, right? If I remember right.
Would this be a desirable location for somebody to have a 3-acre property? I'm not terribly familiar with that, so anybody who knows the
So the
area.
comment to that, we only have access through the
Mall Road,
Mall Road.
which is private.
So you can't tie into another township's public road? You can't just continue that road into our township?
No.
Private road.
It's a private road.
Yeah.
No, the Pohat side, all those houses are
I
right.
don't think any of them come through. If I remember right, they all end. And I mean, the end is cul-de-sacs or cut off, if I remember right.
George, what do you think the best option for success is on that property? What was the answer?
I've always told her, George, that there was a deed restriction with the mall that said once that property was sold in the back, they had to grant them access off of the ring road.
Well, I think that's what our housing project that's under construction originally thought too, and it took them 2 years to get that worked out.
Michael went off of his property onto that property without approval.
Yeah, I don't mind.
Should be tried to.
Yeah.
And then, he was gonna come out the back there. Originally, we turned him down because his back access was gonna be right on the 90-degree turn. The site triangle wasn't there. Then he redesigned the road.
Right.
But the redesigned road went off of his property.
Correct, onto this one.
Onto this one.
Onto this one, and then connects in where the
Right,
site
they
is.
told
Yes.
him he couldn't do that.
Okay.
Then he worked something out with them afterwards to get access to where he's tying in now.
It's coming in,
Right.
you know.
George, I thought that site was 3-2 once upon a time.
It was 5, I looked it up before I
Did
came
you?
up here tonight, yeah, it was 5-3.
5-3, what was it before that, though?
Before that, I have no idea, because the stuff that's along the creek right now is in the old zone district, which is 5-3. And in the old master plan, it's 5-3, I don't know what it was before that.
Does this go up right to the creek?
Yes.
Yes.
Yeah.
A church or something on that property.
The only advantage of cluster on that is it does give you an option if somebody ever pushes it to try to put a stream corridor. Now, I will admit, if you zoned it all commercial, you'd still have all the wetlands, you'd still have all the riparian buffers. In other words, the corridor would get protected, whether we force a cluster on somebody or they try to develop it. The state will come in and say you have a 300-foot riparian buffer, you have wetlands, you have da-da-da-da, which will also establish a corridor. It isn't like you're going to build right up to the stream no matter how we zone it. So, I mean, you know, the stream will get protected, the same way it got protected in Ingersoll, in the corridor.
Yeah, the far southern tip of that property used to be the Paulus farm. There was a house and a barn down there. There's still a flat concrete bridge going across the Lopatcong Creek at that point.
Well, from my heard, I think the housing market is improving a little bit. I mean, you might get some bites on a 3-2 cluster in that area for a development.
But how do you get to it, Eric?
Well, that's,
Well,
I'm just looking at
Because one down there,
Google Maps.
EPA and stuff has pretty much told everybody you can't cross to Lopatcong Creek.
I think Gary is right. If you want to build a house and your only way to get is through the People Mall Road, right, I think that excludes every housing project privately. I think that only leaves commercial as a viable option for me at least. I'm not sure if I'm right.
Agriculture.
Well, Tom wants to build a farm.
There is a farm, that's what it is.
And if I'm not mistaken, George, another municipality.
George, do you agree with that? George, do you agree with that kind of assessment? We've got a
Can you go fishing back there?
issue.
Well, we have an access issue, but one of the ways I look at the zoning of it is, that's not our problem to solve. The question is, what do we think is the best use for the property, and let them work out the access issue.
But the knowledge of the problem to solve could be reason enough to go in a certain direction.
Well, no,
the problem is there.
Sure,
I think you have to assume that you get access.
Watch them go by.
Somehow.
Push comes to shove, unless someone created a hardship for themselves, the courts are going to allow that property owner access
somewhere
to the public thoroughfares in this municipality. And that's just a reality. They may have to negotiate with all owners. Maybe they don't want the time and the expense of litigation, but that really is up to them. I think we need to look at that property and assume it could be, that there is access and it could be developed. What's the best use of the property? That's what I think the analysis here should be.
I think the 3-2, to me, sounds like it's the most viable.
I think we should say no.
We can speak.
Does someone want to have to go through the mall to get to their house every time? Yeah, that's...
around the loop.
Gotta go through Sears, put a gas station in there.
Sears might not be there anymore.
And do you have enough housing? And that's the other question you have to ask yourself.
That's right.
Well,
I don't
that's a
think we
good
need to
point.
do much on this.
Well, you'd have to look at a housing plan and everything. I thought we were pretty well set there with our housing plan, George.
Oh, as far as our going in, housing as it relates to affordable housing, we're in good shape. You're good through 2025, and you're carrying a substantial number of units into the next round beyond that. So you don't need affordable housing units in the near future, shall we say.
I don't know if there's housing pressure at all.
Well, you're also competing against the small property too, though.
That's pretty good,
40 acres.
asserting here the last time?
Yes, it includes Gardner's proposed project.
So without Gardner's proposed project, we would be not in good shape?
No, you'd be in perfectly good shape without Gardner's proposed project.
So we don't need Gardner to build this stuff?
You need Gardner to build his stuff to carry a surplus into the next round.
Okay.
In other words, he's going to take care of a substantial portion. You don't need it in terms of this round. And the only reason I'm saying that's because of the agreed to if approved by council, the agreed to settlement.
Now, in regards to the COA stuff, I'm not sure if we are actually, but I have been told that I'm not sure if that is actually true and has nothing to do with anything here. That, is the town allowed to rent out COA units to other towns?
No, not anymore.
Are we doing that in any way? Is
No.
Lopat,
No.
all our COA units are used by Lopat?
No, that's different. You're saying a different thing here. They're not, you have COA units that qualify to be counted toward your obligation. They're not restricted to Lopat people. In other words, anybody can occupy those units. And in fact, you can't restrict it to just Lopat. And that's
Clymer Manor, we have units.
Clymer Village is not all.
Other towns take credit for. Where's Clymer? Clymer Village.
Yes.
We only get credit for half of it.
That's right. That's exactly right.
Nobody can find the agreement how that.
Well, I don't know. All I know is that, from what I've seen, is half of them went to the other towns.
Right, if we could reclaim those, we would have been in a real surplus, although there is a limit on the number of senior ones, I think.
Who said there's no bridge?
Nobody.
That's the one you mentioned.
Concrete
slab.
It's concrete slab.
That's a bridge.
Yeah, no, I said, that goes to the old Paul's farm. There is a metal bridge that crosses the Lopatcong Creek on Lock Street,
Yeah, that's one I mentioned.
but that doesn't take you to that property. There is a house, there's two houses down there.
Considering the Pohat.
that cross
On Lock Street.
I would go with George, I don't think you made a recommendation yet, Jan, did you?
What, on this?
Yes.
No, I've thrown out about 4 different ways to think about it.
I would like one recommendation from you, like, no,
Then it turns into...
what would be your personal recommendation, what to do with the property?
Well, I gotta admit, if I believed that the retail market was strong enough, I would have zoned it into the same use as the mall. That is my gut, of what would work back there. The only problem you have is whether, without sewer, that's gonna amount to anything either. I mean, you can do retail, but it's gotta be low-intensity types of stuff.
It'd be perfect for mini storage.
If you want to protect the environmental resources back there, the mandatory cluster will help you do that. You know, and you won't get that many houses if you think of 32553. You're not getting a lot of units back there. You are, if anybody wants to build it. The problem with that is exactly what was pointed out here, you know, with the access on the Mall Road, you know, I will tell you, in some towns it would sell. I'm not sure it would move up here.
Now, I would think that the houses, if it is not many houses on a large acreage, the houses are probably fairly expensive houses.
Yeah.
So we're looking at houses 500, 700. I don't think these guys would be wanting driving through the mall. I don't.
Yeah, no, I understand what you're saying. I'm not arguing
If this was
against you.
amended,
You're competing against the Pohat small lot housing.
I think that what Gardner said when he was here last month, he's got over 100 units that he has to rent right now because he can't sell them. We've got
who's this, Tony?
Gardner, who was here last month.
Oh, that's right.
The property values, I think, on the residential side are somewhat depressed because there are so many out there. Why are you building more houses? I mean, that's just my...
That's what I said.
It should stay.
So it's by market. He has.
I think George's recommendation, I'm sorry, you convinced me. I think that,
What's his recommendation?
Well, mine is, I said my gut would be to zone it into the commercial district.
The mall.
And see if there's any desire to expand the mall by the backside
I
for
would say that would
commercial.
make the most sense.
I would be comfortable with that.
That's more agreement, Tony, yeah?
Joe said he
Not
loves the
10
idea.
o'clock yet.
Crazy.
I don't oppose it. I mean, it's the adjacent zone has
If you want unanimous approval, stop now.
Yeah, I think so.
George's only reluctance is,
Well, I'm just not
you
sure
know, really the
there's
shape
enough to
walls
push it,
and-
but I should say that in planning and zoning, the absorption in the market really isn't your problem either. You should try, and even though all of us think about that, what you're trying to do is figure out what the best use of the land is, because if you think about it, if you go in and look through, not only in Lopat, but if you go into the general area, and you see the amount of land zoned for residential, you know, just the hundreds and hundreds and hundreds of acres, well, you know that there's going to be a few people out there that win, meaning it gets developed as zoned, but there's also a very large number of people out there that are zoned residential that in their lifetime, if they ever see their farm sold, developed, it'll be a long shot. So I don't know if it's really important that we think of the absorption rate. What we do is think about what we think the best use of the property should be, and let the owners try to figure out if they can or can't do it. If they can't, they'll come in. They'll come in front of the board and say, I got a better idea on the tract.
You know, one wonders if a commercial property behind the mall would actually help the mall.
I don't know. I
know you don't, but all the auxiliary buildings around the mall, maybe already that is what, I don't know if it's keeping alive, but some other interesting properties behind the mall commercially may be able to sustain what is there, I'm not sure.
Well, they might. I've seen around some of the, if you go in and see the community malls that are being built now, you can go down to Flemington. I'm not talking King of Prussia, which is an unusual aberration. If you go down low to Flemington, what you can see happening is they built the core mall, and now all around the perimeter on the opposite sides of the street, they're getting all the standalones, the Costco's.
All you need is one corner store.
You're getting those kind of things, but it's also predicated on part that the core mall is strong enough to draw people in. I mean, I'm not telling you anything you don't know.
You made the mall right on 202 there.
Yeah, but if
It was
you...
there for years.
Yeah, but if you pull back in now, they're developing
All around there, yeah.
all around it is starting to go into freestanders.
But, maybe it's the REIT and not the mall. I mean, sound management, there's a lot of REITs out there that are, have very successful malls.
Correct. And I think in the Flemington case, I think some of the exterior stuff is owned by the same people that own the core mall. Because it was developed at the same time.
Well, that Costco took them close to 14 years to get that in.
Yeah.
They had that on the books years ago.
Yep. They are, it takes a while.
All right, so what's the
we want-
recommendation here? It's
Somebody wants to make a motion?
I would say if you need a
Just to move forward.
placeholder for now, commercial.
I agree.
Okay.
Are we okay with it? All in favor? Do we need a motion, Beth? All in favor for commercial at this point? Aye. I'll take a motion. I was going to ask for a motion. You're so excited. Motion to adjourn. Do I have one?
Second.
Second. Okay. Meeting adjourned, guys.
Try to get that second.